If a healthcare entity is struggling financially, a merger or acquisition can help consumers by keeping that healthcare option from going out of business. However, concentrating market power can reduce competition and lead to dramatic price increases. For instance, some hospital mergers have resulted in 50% price increases. Thus, the federal government and state governments watch healthcare mergers for potential antitrust dangers. For the federal government, the Clayton Act is the primary shield against mergers and acquisitions that create antitrust issues. Specifically, the Clayton Act prohibits mergers, acquisitions, and joint ventures that tend to either create a monopoly or substantially lessen competition. Even if a merger doesn't cause immediate harm, the merger is still prohibited if it likely will harm the market. Imagine that two hospitals plan to merge. To determine whether the merger created an antitrust threat and was prohibited by the Clayton Act, the government needed to use a two-part market analysis. First, the government needed to define the relevant market. Second, the government needed to determine whether the merger was likely to harm that relevant market. Defining the relevant market can be a complex process. Generally, the widespread use of health insurance creates a two-stage dual consumer market for healthcare products and services. For our proposed merger, in both stages, the hospitals were the sellers. In the first stage, insurance companies were the consumers, and the hospitals and insurance companies negotiated over the prices of the hospital services. In the second stage, patients were the consumers. The hospitals tried to attract patients using non-price factors, such as convenience, quality, and reputation. In antitrust cases, the relevant market has two parts: the geographic market and the product market. In general, the overlap between these markets is the relevant market to analyze for harm.